please rise. The Court of Appeals is now in session. Please be seated.
All right, welcome to the Utah Court of Appeals. We're here in a hybrid session. We have Mr. Jeremy Jones online. And can you hear us? Is everything good?
I can.
And we can hear you. Excellent. We're here for the matter of Small versus Small. And so could I have you make your formal appearances?
Yes, Jeremy Jones on behalf of the appellant Nathan Small. We're both here via WebEx.
And Michael Christiansen on behalf of the appellee. She's not present.
Very good. I see 10 minutes on the clock. I assume that means you're reserving 5. Is that correct?
That is correct.
All right. I know it's going to be a little bit odd, the way the camera angle goes. Your face is showing up on the screen to my right. I just want to let you know that so that when I'm staring to my right, you don't think I'm otherwise distracted, because that's where I'm going to look, because I'm looking at you, but I understand that it doesn't appear so from the camera, just so we're all clear on that.
And that's true for all of us. You are on a screen to our right, so you will get the view of the left side of our face for most of this.
So any questions before we proceed?
I don't think so. Thank you.
Okay, you may proceed then.
We appreciate the court accommodating us via WebEx. I would like to say, before I really get into any substantive argument, we are asking the panel to consider giving guidance to commissioners on how they might handle evidentiary objections or other objections generally in the proceedings below. I think as we briefed, there's really sort of a lack of clarity as to why the commissioner ruled the way they did during the commissioner portion of the proceeding. I understand that that largely falls by the wayside in relation to the rest of the proceedings before the trial court. But maybe perhaps speaking from personal experience, I think it would benefit not only my office, but I think practitioners statewide for this court to give commissioners a little bit of additional direction on how they might want to handle these issues. Because as we've, again, asserted in the briefing, there has been some impact on the way that this case proceeded as a result of that.
I'm glad that you lead off with that, because that leads to an additional question that I have. And we have issued a couple of decisions from our court that point out that when you come up on appeal, it is a rare occurrence where the Court of Appeals actually reviews any direct ruling of a commissioner. And I think that this case is particularly so, where the parties have appealed, or where the district court has conducted a hearing on an objection to a commissioner recommendation. I think the law is that what we're reviewing is the order of the district court, not the actions of the commissioner. There's a couple of reasons for that. And the case that we might want to all consider is Day versus Barnes from 2018, where we pointed out that under the language of Rule 108, we had some district courts kind of doing an appellate review of what the commissioner did, trying to decide whether the commissioner's actions were reasonable, whether they abused their discretion. We said, no, that's not how this works. You have to make independent findings of fact and conclusions of law based upon the evidence. And we also pointed out that by operation of rule, any ruling made by a commissioner becomes an order of the district court until modified by the district court. And then we noted that it would make little sense that the district court would be limited in reviewing what is essentially its own order. So in this case, unless you can help me understand it otherwise, what we really are reviewing is the decision of the district court, not what happened before the commissioner. Is that right?
You are correct. I'm familiar with the Day case, and I was appreciative of the opinion when it came down, because it did clarify that issue, relative to, I think, the way other cases have been coming up or have been being treated by district courts. I think the issue here, though, is exactly what you said. When commissioners make rulings, those are the rulings of the district court, unless and until they're modified by the district court. Here, really, the commissioner's ruling was the same effectively as the trial judges in, ruling on 408. I think the problem though, and we have asserted error below relative to the commissioner, is that, these are two-step proceedings, and there are things that happen in front of the commissioner as well as in front of the judge. Specifically in this case, the representation made to the commissioner that, well, there's no agreement, there were essential key terms that were reached, but, they had to do was this, that, and the other, and they really, needed to work that out. That has carried its way all the way through, as has the sort of late assertion of the statute of frauds defense, right? The commissioner ruled excluding under 408 and the statute of frauds. The statute of frauds, as we've argued fairly exhaustively in the briefing, was waived, having not been advanced during, via any sort of pleading. And so if we're going to attribute commissioner rulings to district courts as orders, then I think that those rulings need to be reviewed for error as orders. The problem in this case is that the commissioner didn't explain the basis for failing to rule on my client's objections.
I
right?
guess,
And
go ahead.
I have to say, I'm a little lost by what I think you're saying is, so taking it to the end that I hear from you is that we'd be reviewing two rulings then? Because the commissioner's order is only temporary, right? It's a recommendation until it goes before the district court. You got in front of the district court had a hearing. All these same issues were before the district court. We have a decision of the district court. So I don't understand how we could review two different decisions that essentially end up in one order, right? Isn't it just one in the whole, and whatever you argued in front of the commissioner, you were entitled to and did argue in front of the district court, and that's the decision that we have to review on appeal?
I think that that's a fair point. In this case, it's probably the right point, at least on a practical level, because the district court essentially made the same rulings as the commissioner. But that's not always the case.
Well,
I think the
if it
problem
was,
that I'm
let's,
identifying-
I know that that's not here, but you keep going back to the point, so I guess that's why we're belaboring it. Let's say the commissioner did something different than what the district court did. Would you then say that we should be going and correcting error in what the commissioner did? It seems to me that, I guess, what would be the legal phrase for that? Why would I care? Is literally the legal analysis, because once the district court rules, if it rules different than the commissioner, then that kind of undoes what the commissioner did, and that's no longer in play. I just don't see a scenario where we'd ever reach down into what a commissioner did if there's an intervening district court order. And there's always an intervening district court order because the district court has to countersign what the commissioner does. I just don't understand how we ever get there.
Yeah, and I think it's fair. And again, it probably doesn't apply to this case. I mean, part of the reason that it's come to the forefront is that the way the rules operate, sometimes the trial courts say, well, you didn't present information before the commissioner, therefore you can't present information before me. We actually we spent time on that point in front of Judge Walsh, and it ended up not mattering in this case. So I think that the court's concern is fair, but I do envision scenarios.
I mean,
where
I think what you're, not to cut you off, but I think what you're saying in this case is that there was a waiver in front of the commissioner, and then the
Yes.
district court went ahead and addressed the issue on the merits, and you seem to be saying, I think, that the district court erred by not concluding that there had been a waiver before the commissioner. Is that what you're saying?
Yes, and you got to the point right before I did. There are evidentiary rulings that the commissioner can make that carry their way through to the district court proceeding. In this case,
But
that's
why,
exactly what
structurally speaking, why isn't the answer in that scenario that the waiver, that the district court gets to decide for itself whether a waiver had occurred? So the thing you would need to be attacking is the district court's waiver, not whatever it is the commissioner did.
And that may be the case. So I think, but direction to the parties on, look, you need to assert error at both levels. I think there's at least one case that asserts generally that, right? That's fair. But I just think that it's a difficult position for litigants who are primarily before commissioners when commissioners exercise such a fairly broad sweep of quasi-judicial authority, right? That, the idea that ruling, which is an order of the trial court, essentially is not reviewed, I believe has negative implications.
But you can always
And
file an
we spent-
objection to anything the commissioner does, right? So
Yes.
you can always take that, whatever the issue is, if you disagree with the commissioner's decision, you can always take that to the district court. And the district court, under
Yes.
Rule 108, has to make independent findings, right? They have to evaluate the issue before you. So I take exception to, I think, to what you're saying, because it's not that you have no ability to challenge the recommendation of a commissioner. In fact, you do, and it's specified in the rules how to do that.
And I agree, and that's never what we've asserted, that we didn't have any ability to do so. What we've asserted is that there were evidentiary rulings and there were admissions of consequence that occurred before the commissioner that were then subsequently mishandled by the trial court. So in this case, it's the same. We objected to the commissioner's recommendation. The trial court made the same errors. Really, the attack is the same. But again, I think that there are potential issues, especially when operation of the rule says that if you didn't present the argument before the commissioner, you can't present it before the trial court. That is a scenario, again, not applicable here, but broadly where there could be a difference that matters for litigants.
I think you'd be best served to move on to the substantive part of your
Yes.
argument. I wanted to ask you about the first part. My understanding is that the motion to enforce the settlement was filed contemporaneously with the counter petition. Is that accurate or not?
It is, yes.
So at the moment you filed your motion to enforce, the time for response where the statute of frauds would have to be raised had not run. Is that right?
That's correct. So both the motion and answer were filed contemporaneously. Both raised the existence of the agreement, asserting, involving real property. No response was filed to the motion that raised the statute of frauds, and no answer was filed that raised the statute of frauds, which is why we assert that that defense was waived.
And I want to jump ahead also. So as I understand the issue with the recording, the audio recording, is that you are seeking to use it only for impeachment purposes. Am I correct in that assessment?
That's correct. Tricia
Okay.
has essentially denied the existence of an agreement, and the recording would serve to impeach that denial. And then given Nate's assertion that there is an agreement, that would be an evidentiary basis for the court
Well,
below to conclude
your
that
answer
there
sort
is
of-
an enforceable agreement.
Sorry, your answer sort of begs the question. Are you only offering it for impeachment, or are you offering it to affirmatively prove your claim that there is an oral agreement?
That's the interesting question of this case. I mean, when we have a very narrow issue, is there or is there not an agreement?
Well, in your view, as the
And-
attorney for Nathan, are you offering it only for impeachment, or are you offering it to affirmatively prove that there's an oral agreement?
Narrowly, we've only ever presented it for impeachment purposes, right? Because we don't want to run afoul of the rules limitation on utilizing this material to prove or disprove liability. But that's really the problem here, is that if somebody is going to take refuge in Rule 408 and deny the existence of an agreement that they made, right, then all we have is the other party's assertion, well, there is in fact an agreement. So now we have a quantum of proof question. Well, how do we prove one way or the other?
If you're only offering it for impeachment, how do you intend to prove that there was an agreement?
Nathan's assertion via his declaration, which was presented before the trial court, that there is in fact an agreement.
Which, as I understand it and as I read it, the district court's order also bars.
Yes.
Okay.
Yes. And so.
So there's really, correct me if I'm wrong, there's really two things going on here. You're trying to present Nathan's testimony, which the district court has barred under Rule 408, and you're also trying to present the audio as impeachment, which the district court has also barred under Rule 408. Do I have that right or wrong?
That is correct. And then collaterally, we have an admission before the commissioner that by Tricia's counsel, that they did reach key terms on an agreement. And so we have a separate avenue. And we also have a fourth avenue, which is the presence of the third party, Devin, who participated in the discussion and took notes. And so we attempted to, we weren't permitted to call Devin because the district court truncated the evidentiary hearing.
Do you have any case in Utah that says that Rule 408 creates a privilege at all?
No. And that's
So
what we
why
have
is the
to do.
presence of a third party relevant?
So the that's sort of an argumentative exercise. So essentially, the presence of a third party matters because if there's a non-privileged relationship, right, with that third party, and that third party, and as we have alleged in this case, took notes, Rule 408 doesn't sweep broadly enough to exclude the facts, right, the independently discoverable information. In this case, that would be the notes of the discussion, the notes that would reflect that there was in fact an agreement. And so arguing about privilege was really prophylactic. We wanted to make clear that this is a third party that doesn't enjoy any sort of privileged relationship. And so their presence alone is enough, we believe, to render the discussions accessible under the second exception to Rule 408. Minimally, again, as we stated in the briefing, the notes of that meeting should be explorable.
I don't fully understand that, but you've spoken of it in.
I think you lost me too.
Yeah, you've spoken of it in terms of privilege. I had the same question that Judge Mortensen had. Let me come at it a different way. You've made the argument in the brief. I think you've couched it in privilege terms. You said that because you've got this third party, Devin, who's there, that it would sort of waive any privilege in the sense of if I invite a third party into my discussion with my lawyer or something. But one of the things that struck me as I was thinking about this is the privilege rules are set forth in the 500 series in the Rules of Evidence. This is not in the 500 series. It's in the 400 series. It's in the relevancy section. It doesn't use the word privilege. It doesn't use the word confidential. I'm trying to figure out why we would regard Rule 408 as a privilege-based rule at all when it doesn't talk about it in these terms. Why would we
That's
talk about
right.
it in these terms?
That is right. Perhaps we couched it inartfully. Really, the argument to privilege is an analogy, right? I mean, you're exactly right. Rule 400 and Rule 408 don't create a privilege, right? What we've argued essentially is that, look, the legislature has, granted broad statutory protection to discussions in other contexts like mediation. They haven't granted it here. And so Rule 408 really needs to be evaluated on its own terms. It's not a privilege, right? And because it's not a privilege, if we have a third party who's not a participant to the settlement discussions present, right, particularly when that person takes notes, that is otherwise discoverable material that falls under the second exception to Rule 408. Now, we argued...
But I'm going to stop you there, though. So this isn't evidence that's otherwise discoverable. This isn't the photograph of car accident. This isn't a medical report talking about causation. That's what the B2 exception is designed for. Just because you brought documentary evidence to the mediation or to the settlement discussion doesn't cloak that evidence in Rule 408. It says that's separate. You could do an RFP for that. So you can get that evidence. The fact that it was brought to the settlement, discussed at the settlement, that doesn't protect that underlying document. What you're talking about, though, as I understand it, are notes that detail what the settlement is, right? So this is essentially the notes from which a written settlement agreement would be formalized, right? We're not talking about documents that are otherwise independent of the settlement, right? This is the notes from the settlement itself. Do I have that correct?
Yeah, your sort of analytical distinction is accurate, right? This isn't, talking about photographs or, something of that nature. But
So the thing that matters here isn't the fact that there's a third party. The thing that matters is whether the notes themselves are discoverable.
yes.
So why are we talking about the third party part at all?
Because we believe, again, we were never afforded the opportunity to access that. The district court prevented us from proceeding.
Right. So that's
the
just the
examination.
pure 408 argument you've got.
Yes.
I mean, we're just
yes.
speaking personally. I'm just trying to zero in on why it matters that Devin is Devin.
So if we have notes, right, that reflect an agreement, again, those impeach minimally Tricia's claim that there was no agreement. I mean, the issue...
And
Right,
that would be true whether Devin took the notes
Yeah.
or whether Nathan took the notes. So why does it matter that Devin's a third party?
all we have been arguing is that there are multiple avenues by which we should be able to access or impeach Trish's claim that there was no agreement. And so if Devin is present as a third-party witness, he can testify to whether or not there was agreement, right? To impeach Trishna's claim that there was not.
And he's in the same position
Notes
there
would
as
reflect that.
Nathan in that regard, right? Devin and Nathan are in the same position vis-à-vis Rule 408.
Yes.
Okay.
I see no other questions. You were responding to us, so we'll give you your full rebuttal.
Thank you.
Counsel?
Yeah, thank you, Your Honor.
You can go
Oh,
ahead.
thank you. May it please the court. The central issue on the interlocutory appeal is the application of Rule 408 and whether or not the commissioner in the trial court correctly applied it, and whether or not the impeachment purposes that are being sought have an appropriate limit that's being articulated here. I think all of your questions appropriately address the issue that this is really a district court issue, and whether or not the evidentiary hearing appropriately requested by this respondent was conducted and fulfilled in an appropriate manner.
Okay, let's shoot past the commissioner issue, and let's just go right to Rule 408, and let me lead you with a question. I'm going to start you with the softball just to set the ground rules. You agree that in Utah, oral agreements can be binding, right? You can have a verbal agreement.
Yes.
How, in your view, would one prove that a verbal agreement had been reached?
I think there's a number of ways that it could be reached, but I think the statute of frauds applies to some degree.
Put aside the statute of frauds.
Not applying.
How, in your view, can someone prove that a verbal agreement has been reached?
I think subsequent writings between the parties could reference an oral
Well, so
agreement
now-
or
but
support,
now
or
you're talking about-
subsequent actions.
Let's just suppose that you have an oral agreement that's not reduced to writing. Is that a thing in Utah?
It can be. The question is whether or not the oral agreement was phrased and the only evidence you have is whether or not it's from it's a compromise.
So at the 1,000-foot level, let me just start there. Do you agree that there can be an oral agreement in Utah, even if it's not reduced to writing?
Yes,
Okay. How would one prove that
Part-
the agreement had happened?
partial performance. There should be some performance and follow-up actions by both parties in that regard.
Okay, and so then if there's a lawsuit based on a verbal agreement, and one side comes in and says, we had a verbal agreement, and the other side says, no, we didn't, how does the first party get to prove that there was a verbal agreement?
Say that one more time. So
Let's say you've got party A and party B. Party A says, we have a verbal agreement. Party B says, no, we don't have a verbal agreement. So party A sues to breach of the verbal agreement. How does party A get to prove that there was a verbal agreement?
absent some other performance and actions by both parties that adhere to that agreement, I think it would be extremely difficult. I don't see how they could do it if they're only relying on a compromise negotiations that's from one setting in which
I
both
don't-
parties left and gave different instructions.
Rule 408, help me if I'm wrong here, applies to settlements, right? So there's
Yes.
an underlying claim. So the real scenario isn't just the simple question of can there be oral agreements? It's an oral agreement to settle something else. So, for example, let's say you had an oral contract to paint my house, and you breached that agreement, and then we have a subsequent conversation about how we're gonna resolve this dispute. That's where 408 comes in, right?
Correct.
408, is 408 applicable at all to our original conversation about you painting my house? There wasn't an existing
No.
claim, so that's not a 408 conversation, right?
Correct.
All right, so it's the subsequent conversation where we're gonna settle, there has to be an underlying claim, right?
Correct.
And what 408's going to is whether I'm liable on that underlying contract, right?
Yes, that's correct.
Okay. If the evidence to be presented doesn't establish that I'm liable on the underlying contract, only that we reached a settlement, how is that violative? Do you understand what I'm asking?
I think so. I think, again, if the underlying settlement refers to an amount or a liability issue, then 408 directly prohibits that evidence. That's what the plain language of 408 directly implies.
Let me give you a concrete example. There are some federal court cases, they're contract cases, and the parties actually enter into a written contract. So we have a contract, and the question is whether there's a breach of the contract. In these federal cases, look at the settlement negotiations, and if somebody says, well, during our discussions, you said X, Y, and Z, which basically admitted the breach. Those cases say, no, that's out under 408 because it was during those settlement negotiations.
Correct.
But as to the issue of whether we settled, whether we reached an agreement, that's not prohibited by 408. If those federal cases say that, are they wrong?
I don't believe so. I think, again, if there's an existence of a settlement agreement, that's after the fact. In this case, that's not what we have here. I think we specifically have a commissioner, a statement by counsel, and a direct question from a commissioner that's being referenced here that was also addressed in direct questions directly to Trish, where she said there was no agreement. That was
Right,
clarified
but
directly. So
Nathan is telling us today on appeal, and I think it's consistent with the approach he took below, that he's trying to offer two things. One, he's trying to testify we had a verbal agreement as to how we're going to settle our potential divorce. And two, I've got an audio of it. So as to the first part of it, he wants to say we had an agreement. So why isn't that covered by Judge Mortensen's question? Why can't he come in and at least say we had an oral agreement and here were the terms? Why can't he say that?
Well, whether he can or not, the question is whether or not he can purport the liability to my client by only referencing the compromise negotiations against that.
But the liability would come from the breach of the agreement. That's the second step. The first step is, do we have an agreement? And now we're back to my question. How does he get to prove that there was an agreement in the first place?
In this case, he can't prove it by only using prohibited 408 evidence.
So
So that's what he's only seeking.
What would that do to the doctrine of, I don't know if it's a doctrine, what would that do to the legal concept of verbal agreements if you can never come into court and say, in our discussion, this is what we agreed to? How could you still have verbal agreements as a matter of law?
Well, again, you would have to, it depends on the nature of the claim that would come from that agreement. And specifically, as addressed here, you have a coupling of claims. But there's only one settlement conversation that the parties both interpreted very differently, appears like.
Let me ask this, because I think what Judge Tenney's getting at is the mere fact that an agreement was reached, not any of the terms, not how it assessed liability, not how it valued the amount of the claims,
Sure.
right? Seems like it's different than Rule 408, right? Because the fact of the agreement, yes, we reached an agreement to settle this case, does not reveal any of the actual communications or does not reveal anything about liability or the amount of the claim, right? It's just the fact that a settlement was reached. That seems to be outside of Rule 408. Are you saying that it's inside Rule 408?
Well, I think that, maybe I'm getting lost in the distinction, so I apologize, Your Honor. And so what I'm hearing is there was an existence of an agreement, which Trish disputes that there is an
Certainly.
agreement. And so whether or not the framework of the agreement is we have an agreement to come back later and keep talking about it, and that's what she was referring to, or I was referring to, I guess then to raise the issue that if there is an existence of an agreement, so now we could go ahead and pursue 408 evidence to try to get to the heart of the matter of liability.
So that's a different question. I think there's two things that are separate, at least in my mind, and maybe I'm not looking at it correctly. So that's part of the reason I have this question, is as I read Rule 408, you can't use evidence that you want to use, and I'm reading from subsection A, to prove or disprove liability for or the validity or amount of a disputed claim. So you couldn't use any evidence from the settlement discussion to prove the validity of the claim. So, let's say it relates to the house here. We'll just use the house as the example. The validity of the claim to the equity in the home and the amount of the claim to the equity in the home. But couldn't the evidence be admitted that we agreed to a settlement with respect to the home? Because that doesn't necessarily involve the amount or the liability. We just had an agreement. Now, I think the second step, and maybe this is where you're getting to, that it gets a little more complicated in my mind, is how do you prove then what the agreement was? because it's the terms of the agreement that do implicate the validity of the claim and the amount of the claim. But it seems to me that you can carve out, we did reach an agreement.
I think it's extremely difficult to weigh whether or not the parties' concessions, all the way up until the practice of putting it in writing and putting it on paper, can then turn around and be dissected backwards. I guess that's the issue that
Do you-
408
do you-
sort of
do you-
directly kind of puts
Do
a
you have
bar on.
any case that says, that delineates and cabins Rule 408's parameters based upon whether something was put in writing? You put great significance on this, well, I mean, how does that change things if something's put in writing?
Well, in this case specifically, the 408 language of compromise statements and evidence from compromise statements is what I am leaning back on, Your Honor. And so I'm really looking at any evidence that references those compromise statements are prohibited. And so taking the evidence of the compromise statements and turning around and saying, well, there was a reference to an agreement, but we're not going to deal with the materiality of each concession and whether or not that reached the totality of an agreement or not, that never got reduced to writing. That's what 408 has some restrictions on, saying specifically, we would rather bar that. I think the posture that my client is asserting in the legal presentation that we have is that it's greater when there's an issue like this is to prohibit it rather than to admit it and start parsing out each concession that was made in the efforts of trying to get to a written agreement, and whether or not amounts or details of that agreement can then be dissected backwards just because a reference to an agreement is asserted by one party and disputed by another.
So I don't read Rule 408's reference to a statement to reference a writing. So the prohibited uses under Section A have two subsections. One doesn't reference a statement at all. It's furnishing, promising, or offering, or accepting, promising to accept, or offering to accept consideration to compromise the claim, right? And that doesn't reference a statement in any way. That's just, I'm offering or I'm accepting to compromise my claim. And then A2 says conduct or a statement made in compromise negotiations. So conduct or a statement to me means I said during the conversation at the settlement that I would accept liability in this amount, right? That's the statement. I don't read anything in this rule to reference a writing by the rule itself. So are you reading Rule 8 to say that the statement reference in A2 references a written statement?
No, I'm not referencing that. I'm saying that it would include both conduct and statements. And so any assertion by, in this case, by Nate saying she said this or she said that, or I want to solicit questions to impeach what you may have said against a recording of that same compromised negotiations, those are prohibited acts. And so whether or not she ended up writing down that.
Can he say, quote, in our discussion, she agreed that, I'm just making this up, I know this is not the agreement, but could he say, quote, in our discussion, she agreed that I would get the house and she would get the cars? Could he say that?
Could he say?
Could a hypothetical husband, I don't want to get lost in the weeds of this case.
Could he testify to the district court that
Yeah.
that's what
Could
the
a
agreement
husband
was?
in this scenario, let's just abstract it out, random husband X, random, wife Z. Could husband in that scenario say to the district court, quote, in our discussion, she agreed that I would get the house and she would get the cars? Could he say that thing?
I think those would run afoul of 408. I think those are prohibited references, specifically referencing either a statement by her or a purported conduct by her in response to a statement by him, and also trying to say she accepted that offer or made an offer. So I think those are specifically prohibited acts. Yes, I think they're specifically barred by 408. And I think the courts are better served by barring those.
So if you were in our shoes and you were writing that opinion, how would you write that opinion and still leave open the possibility of purely verbal agreements in Utah?
Well, again, I think verbal agreements that are outside settlement negotiations, I think those are obviously, that's the distinction here. You have two parties that.
Hold on, what does that mean? I mean, you enter a verbal agreement in a lot of cases because you have a dispute and the agreement resolves the dispute. So you're just saying you can't have a verbal agreement if you're in some sort of conflict. Is that what you're saying?
Correct. If you're in a compromise negotiations, which is what 408 addresses, then you're barred by bringing those back in through that sole four corners of those conversations. And that's specifically what you're faced with here. You have two parties who say, yes, this was our compromise negotiations. And 408 creates that clear safe space for these conversations to occur. And courts are best served by that specifically. I think they allow these two parties to continue to negotiate. If you don't have that safe space for these parties to make these concessions, then you run afoul of, I think, the purpose of negotiations and mediations, which is to allow parties to continue to go back and forth in these type of settings to try to finalize the verbiage to reach a global agreement on a range of contested claims, rather than piecemealing each individual claim. So negotiations and mediations, whether present with a third party or not, whether or not some party takes notes or not, is irrelevant to whether 408 bars those conversations from being raised in any pleadings. And that's what we're specifically saying applies here. And I think both the district court and the commissioner correctly applied.
Can I take you to the statute of frauds issue unless, I don't know.
No, I was gonna do the same thing. So
Do you want to go first? You're in the middle.
Sure.
Yeah.
Outside of this, the facts of this exact case, let's say two parties are anticipating that they're going to get divorced. And at some point, they anticipate needing to know the value of a home. So they said, we can just envision, at some point, we need to know what this house is worth. And so we are going to agree to get an appraisal of the house.
Sure.
That's all they agree to. All we're gonna do is, we think we're gonna need an appraisal in the future, we're gonna agree to get an appraisal. Does that invoke the statute of frauds at all?
No, I don't think so.
Because it doesn't effectuate any transfer of an interest, right?
Correct. It's just a conversation as to value.
Okay.
Okay, that leads to my question. What part of this purported verbal agreement triggers the statute of frauds? I'm trying to figure that out. And I don't mean that to be a fastball. I mean that sincerely. In your view, what thing that he's trying to say they agreed to is the trigger for the statute of frauds?
That there's a global agreement that includes real property. And that global agreement, whether for value and offsets and how that was
Okay, so
conducted and included.
I'm looking, I probably should have just printed it off so we have it, but I'm looking at the record, the declaration from Nathan that he attached to his motion to enforce. And as I understand it, this is what he's proposing is the verbal agreement, and it's on record pages 69 to 70. Are you familiar with that
Yes.
declaration? Okay. Do you happen to have a copy anywhere
No, I don't.
handy? Okay. I'm looking at it, and I'm not seeing a term that says, what was the phrase you just used? Global, what?
A global agreement that includes the transfer of real property with the parties' offsets.
I may be missing it. I don't see a term in his proposal that actually transfers the property. The closest thing that I see is this is paragraph 4E. He says, quote, I agreed to vacate Marshall is spelling it. I agreed to vacate the marital home and cede possession to Tricia as soon as the settlement was reduced to writing. That seems to be the closest thing that we've got. I don't see anything more pointed. I don't see a proposed term that directly transfers the title to the property from one party to another. Am I missing something there?
So whether the argument is that there wasn't a purported agreement because there wasn't material terms as to the transfer, or whether or not the statute of fraud applies, I didn't review it that way, and I apologize. I'm not familiar with the declarations with that
I mean,
particular.
the statute of frauds isn't the clearest statute in the books, but it on its terms, it talks about applying when an interest in real property is created, granted, assigned, and there's a couple of other verbs. But it's talking about the assignment of an interest in property. So let's just assume that this is the closest thing we have in this proposal. I agreed to vacate the marital home and cede possession to Tricia as soon as the settlement was reduced to writing. What part of that creates, grants, or assigns an interest in property? He's just talking about moving out, and then he's contemplating that there's going to be a future written agreement.
So yes, statements in regards to the temporary application of the two parties' effectuating of a future agreement or having something written down future. I don't know if that would trigger the statute of frauds here, but
So if
asserting
that
that there
doesn't
is
trigger,
a
if that doesn't
global.
trigger it, what else in this does trigger it?
Well, here you were dealing with a motion to enforce, saying all of the terms of the parties of the decree of divorce should be entered in a particular way presented by one party, only citing unilateral positions that he took from a compromise negotiations.
Okay, but you're
that
saying this,
he's-
you're saying the statute of frauds bars the agreement that he's saying they entered. So in order to figure out whether the statute of frauds would actually bar that agreement, we've got to find some part of the agreement that would trigger the statute of frauds. Fair?
Correct.
Okay. So I'm looking at that. Do you think that an agreement to cede possession as soon as the settlement is reduced to writing, do you think that would trigger the statute of frauds?
No, not necessarily.
Okay, so
Not-
the
not
other one
as
that I
narrowly
see in
as-
his bullet pointed list that maybe gets there, he says in subpart K, quote, "We parties discussed the upcoming appraisal of the marital home, which I had paid for and agreed that the number from the appraisal would be used to set the value of the home so we could divide the equity per our agreement." Would that trigger the statute of frauds?
Perhaps.
How?
Well, again, if a future act is trying to be asserted as enforceable against her, I think, and it's not reduced to writing, and again, it's used to enforce.
Why does that trigger, if that's an agreement, that the equity, the upcoming appraisal will be used to set the value so that they could later divide the equity, how does that trigger the statute of frauds?
I apologize, I may have heard the last phrase of your question and interpreted it incorrectly. If
Yeah.
it's just to get the appraisal, no, that doesn't trigger the statute of frauds,
So,
if that's the narrow question.
so why, this agreement, at least as it's written, I'm not seeing anything that says that the property goes from A to B. So what part of this agreement makes this a statute of frauds case?
Again, as the motion to enforce asserted, an enforcement of that agreement that effectuated the transfer and was interpreted by the way that it was presented, again, both by counsel and by Nate when he took the stand, I think, or he didn't get a chance to take the stand, but as it was purported would be presented, that's what could trigger the statute of frauds. So if he took the stand and then turned around and said, here's our provisions, here's what I agreed to, and I want to use this recording to create this impeachment in regards to how I determine value and how this transfer should occur, the statute of frauds would have directly prohibited that act.
I guess,
And so maybe
Follow
I'm
up.
getting those two questions.
well, you
compounded.
keep talking about a transfer, and Judge Tenney's saying he has looked at the affidavit, which purports to have the terms of the agreement, and he can't find the word transfer or any like word in there, so.
Yeah, other than his leaving the home, correct? There wouldn't necessarily even be a language enough for an agreement.
I'm not a property expert. Does the statute of frauds apply to an agreement to leave a home?
No, not on its face.
Okay. So for the statute of frauds to apply, we're going to have to find somewhere in the record that shows that the purported oral agreement was specific as to the transfer title. Is that fair?
Yes.
Okay. And if we don't find that, then,
There's no application because there is no written agreement for the transfer, and there is nothing other than references to compromise negotiations, correct, that are prohibited. So the statute of frauds may be devoid absent any reference to an agreement, which if you can't find in the record,
I may have missed it. So please correct me if I'm wrong.
Again, I think that was purported testimony that was argued that I may have interpreted incorrectly
Right.
from the declaration.
And if you get back to your office and you see that I missed it, please let us know through a 24J letter. That's always appreciated. It wouldn't be the first time. So.
Okay, thank you.
Any other questions? All right, thank you, counsel.
Thank you.
Mr. Jones, your rebuttal.
Can I just start you off there? Did I miss anything there? Is there something in the proffer on the oral agreement about the transfer of title?
No. So all they agreed to do was what was stated in the declaration. My client did partially perform by getting the appraisal exactly as they contemplated. And as we set forth in the record, when the appraisal came back higher, that's when Tricia reneged. Devin attempted to negotiate with my client to change the agreement. My client referenced their prior oral agreement, said he wouldn't go back on it, but he would be willing to consider amendments. And that is when Tricia filed her petition, which then alleged something inconsistent with the oral agreement. So I would like to distill our position as succinctly as I can on the actual substantive issues rather than the sidetrack commissioner issue. Oral agreements are enforceable in Utah. That's very, very clear. And Lawrence, which is cited in our principal brief, states that if a written agreement is intended to memorialize an oral contract, A subsequent failure to execute the written agreement does not nullify the oral.
Why doesn't it matter? In response to our questioning to the opposing side, he says that what's different here is that this isn't an oral agreement between two contractors, which, Judge Mortensen's question, a homeowner and a contractor. That what matters here is this is an oral agreement between two would-be litigants. And so from its inception, it only arises in the course of settlement agreements. And that's why, in his view, it puts it under 408. Why is he wrong about that?
That's an interesting question because Rule 408 contemplates a claim, which I think has a particularized legal meaning, perhaps, right? Whether that means an action would already have to have been instituted, I'm not sure. In this case, there was no action at this point. And I think that the record doesn't bear out the idea that this discussion was only had in contemplation of basically a dispute, right? Or imminent litigation. That's not in the record, right? What is admitted on my client's side of the equation is that the parties met. They wanted to try to come to an agreement regarding the terms of their divorce. They had a discussion in an effort to do that, and they did so, and they came to an oral.
So is it your position then that because the petition for divorce hadn't been filed, Rule 408 doesn't come in at all?
That's one way to get there on the idea that Rule 408 only.
Do you
offers
have, I mean, that seems
I just
A
have
big
to, I
surprise.
just have to tell you, I just spent an hour and a half before we came down here reading two treatises on Rule 408, and I have to tell you, there's an immense body of law against you on that.
I agree. I just said that
Okay.
that's one way.
You could look at it that way, it's just that all the cases say that you're wrong, because
Sure, and-
usually there's a fight about whether litigation's imminent or
Yeah.
anticipated by the parties. If the parties sit down to split up their stuff in anticipation of filing a divorce action, I challenge you to find any court that says that isn't a claim or a potential.
No, and I agree, and that's why I specifically reference imminency of litigation
All
and
right.
things like that. All I'm asserting is that our record doesn't answer that question in this case, right?
But
So-
let me, and I wanted to ask you anyway, that's important, the last point you just made, because you're not asking us to issue a judgment that has been a final accord and that it's enforceable. All you're asking, you were quite specific in your brief, is that the case should be remanded for the court to properly apply Rule 408 and move on to the remaining legal questions that would then flow from that, right?
That's exactly right. I mean, that is the issue here, is if we can have oral agreements and they're enforceable in the absence of a writing, how does a party prove up an oral contract if another denies?
I think what he's saying is you just simply can't have an oral agreement in the settlement context. I think that's what he's saying.
That, and I agree, and I think that sweeps too broadly because that would allow parties to come to agreements in the context of any broad-based, squishily defined settlement discussion or compromise negotiation, and then renege on that and use 408 as a shield to suborn their denial of an otherwise enforceable contract. That's not what our case law says. Oxgathorpe says specifically that you can impeach parties by accessing these discussions. And so I think based on that case alone, we have the ability to prove up the existence of the agreement. Or at least
So let me stop you there. I want to
Yeah.
be clear as to what you're asking. Are you asking, and this is the questions I was asking the other side, are you asking only to prove the existence of the agreement, or are you asking to prove the existence of the agreement and each and every term of the agreement?
That's an interesting question. I mean,
And I'd love an answer to it.
yeah, and I'm going to try my best. I mean, first of all, yes, we need to be able to prove up the existence of an agreement. And we're operating in sort of two different pools here. We have this contract law pool, and we have, whatever our limitations or bounds are that are created by 408. But essentially, if you have an oral contract, the contract question for the court is, well, then what are the terms of the contract, right? So we could establish the existence of agreement, but the court has to ask, what are the terms of the contract additionally? And again, I would assert that if a party is going to lie about what the terms of the contract are, and they can be impeached on that point, that would be available under the rule, the exception to the rule.
So if this ruling went your way, your intention is to put your client on the stand and march through each and every term that was agreed to during the settlement discussion, and then have and I'm sorry, I've forgotten her name, Mrs. Small, I've forgotten her first name, take the stand and ask her the same questions. And if she disagrees in any way with your client's testimony, you're going to play the recording to impeach her. Am I correct that that's how this would go?
Yeah, I think that's largely right. So essentially, my client submitted a declaration asserting the existence of the agreement in the essential terms. That would be his trial testimony, so to speak, right? We then attempted to ask Ms. Small, was there an agreement? To which the 408 objection was raised. We were prevented from inquiring on that point, right? But we would, I think, subsequently ask, did you agree, yes or no, to this term as itemized in Nate's declaration?
Right, and if she said no, excuse me, if she said no, you would then play the recording. So Rule 408, I mean, it seems obliterated, to be honest, in that scenario, right? Because you are using evidence of offering, accepting, promising to accept valuable consideration to compromise a claim and the amount of the claim, right? Those are exactly the things that are prohibited, right? And I understand you're arguing an impeachment defense for asking the questions of Mrs. Small, but what's the exception for allowing your client to testify to those? How does he get to testify about that?
So, I mean, again, that's the problem here, is if there's an oral contract that's enforceable, the court is charged with determining, is there an agreement? And if so, what are the terms?
So then
right?
your position, I'm just trying to distill this because it seems like we're at odds in two very broad brushes. So your view of Mrs. Small's position is that 408 precludes any oral agreement to settle a case ever. And your position seems to be, well, 408 can never apply to an oral agreement in a settlement conference. So we're at two very extreme ends, and so I mean, neither seems all that palatable, to be honest.
I think our position is more narrow than that. So our position is that when a party lies or misrepresents the agreement, they are subject to being impeached on that front. And so if
But she would never be in a position to, as you put it, lie about it unless you're allowed to first try to prove that there was an agreement.
which we would have to do under Utah law.
So
right?
you'd have to start.
Contracts are
I mean,
enforceable.
Nathan's testimony would have to come first, right?
Right,
Because
so-
otherwise there's nothing to impeach her about.
Right, so in order for Nathan to testify, Rule 408 simply can't apply because there's no exception in Rule 408 that would cover Nathan's testimony because it's not impeachment. So that's what I'm trying to understand, excuse me, under your position, Rule 408 just doesn't apply to a verbal agreement reached during a settlement conference. Period, right? It has to be.
Yeah, and that goes back to, well, is it a claim? When does 408 attach, right? I think that those are questions that we don't have answers for in the extant case law. But I suppose there are multiple ways that we get at this, right? We have contemporaneous writings, which may or may not, carry the same considerations. We also have collateral admissions by Tricia in court that there was agreement on essential terms. And we have case law, the Anderson case, that says there is an opening the door exception that will allow parties to explore, again, those communications.
Right, but that came after
when
your
the door is
client.
open.
Your client had asserted the agreement, right? I mean, those admissions that you claim her counsel made, right? About that came after Nathan asserted the agreement. And that's
Yes.
where I seem to be hung up at least is how does he get to testify about what the agreement said unless we say Rule 408 just doesn't apply wholesale to this situation?
Yeah, well, and think about this. I think you need to think about this in the procedural posture in which it arises. My client raised a claim that there was an agreement. Tricia made an objection, but she also, and this is critical, I think, collaterally claimed, she represented to the court that there was no agreement. So I think if this case arose in a different procedural context where my client had simply volunteered his statement that there was an agreement, you might be right that 408,
But-
would
but he
limit their
did,
ability
right?
to offer that.
Is
He
it-
did, but.
But correct me if I'm wrong chronologically, she only does that because you've already filed a motion to enforce.
That's correct. That's correct. But it's the representation that there was no agreement.
Right, but she's
my
only
client-
making that representation because you filed a motion to enforce the verbal agreement. So their point is the Rule 408 motion, or the motion to enforce is sort of void from inception because you're not allowed to do this.
Yeah, and that may be what they're arguing, but that's the question that this court, I think that this case asked this court to answer is 408 that broad? Does it protect parties from subsequently denying their actually reached oral contracts? Or are the exceptions to the rule available to impeach a party when they deny an oral contract? And again, we have reliable evidence on that point in the form of the recording. And so I understand the tension that the court is concerned about. I don't think that what we're asking for from my client's side sweeps as broadly as been characterized. We are responding that, my client asserted that there was an enforceable oral contract, which he's fully entitled to do under Utah law. And then the rest of this really spiraled out from the statement, the claim that there was no oral contract, which is falsifiable for an impeachment purpose to give the trial court an evidentiary basis to determine that there was in fact a contract. And again, we have partial performance, right? So if the other side is admitting that partial performance is the key to indicate some collateral act that would indicate there was in fact a contract, which there is other case law on, we have that in this case. And so we get there, maybe it's all nibbled around the edges, but by the time all the nibbling is done, I think that this case falls within the exception to the rule.
All right, I don't see any other questions, and you're all at zero, so I think we're done for the day. We appreciate your briefs in this matter and your oral argument today. I think it's helped us understand your positions better, and we will issue a decision in due course. Have a good day.
Thank you.